monitoring our chat for audience questions. Wanda Marie, would you like to just say hello?
Hello, and good evening, everyone.
Hi, this is Marie. Keep me busy with those chats.
All righty. I'm going to go over some housekeeping protocol. Please stay muted during the presentation to minimize any background noise and distraction. The microphone button will mute and unmute you if you're using Zoom. If you're on a phone without a unmute button, *6 will mute and unmute you. We have a lot to cover this evening, and we want to get you out on time. So after the legal aid presents, we have 45 minutes for questions, and that will probably start at 7:15. Please hold your questions until then, or use the chat feature on Zoom to get your questions in while Mr. Fitzsimmons is presenting. We're ready to start. I'd like to introduce Mr. Matthew Fitzsimmons, attorney from the Legal Aid Society of Greater Cincinnati, to talk about their role in the Sewer Backup and Prevention Program, program qualifications, and the Metropolitan Sewer District legal responsibility. Mr. Fitzsimmons will also cover some helpful tips for navigating the program if you qualify. So with that, Mr. Fitzsimmons, the floor is yours to begin your presentation. Thank you.
Thank you very much. My name is Matthew Fitzsimmons. I am an attorney with the Legal Aid Society of Greater Cincinnati. However, I am also, I work with the Ombudsman's Office. The outgoing Ombudsman is Marquita Gillum. She has retired, and so we are in the process of having a new Ombudsman appointed. So as we sit here today, it is actually still officially Marquita, but subject to the court's approval, I will be nominated to fill that role. I say all that to say that while I am an attorney, I am not acting as an attorney in this role. The Ombudsman's Office is sort of a unique creation that is what was created under the auspices of Judge Spiegel during the beginning of the execution of the consent decree, which we will get more into later. But the primary limitation to that is because because our office is occupying an ombudsman's role, that we are not providing legal advice and are not attorneys for individuals in regards to this. I obviously have my own legal clients, but not for this particular area. So wanted to make sure that everybody was aware of that. The Ombudsman's role, or the Ombudsman's Office, was created by an order appointing legal aid to serve in that capacity as part of the consent decree. The consent decree is a, for lack of a better term, it's a settlement agreement that was entered into by the county and the city and the various defendants and plaintiffs as part of the lawsuit that was brought regarding the Clean Water Act. I believe it was in 2002, but the consent decree was, I think, entered into in 2004. And there's a lot of things contained in that. But we're here tonight on the water and basement, or SBU program. It's known in the consent decree as water and basement. That has since been rebranded to SBU, or Sewer Backup program, which was established in the consent decree, in that settlement agreement, as a program that would be run by MSD with some judicial review on occasion in the Southern District of Ohio, where the initial lawsuit was brought. The SBU program and water and basement program is outlined principally in 3 different exhibits that were attached to that settlement agreement. Exhibit 6, 7, and I believe 8 as well. And those outline the process for reporting a water basement or an SBU issue to MSD, what MSD will be doing, and then prevention. And then there's a claims process as well, or an appeal process as well. So those are really the governing documents. And I want everyone to be aware that those are out there, they exist, you can find those. And I believe those are available in various forms on the MSD website. So here with us tonight actually is also Tom Frank, who works with MSD. He is one of the point people for the water and basement or SBU program. SBU is probably how I will refer to it. And Tom, can you confirm that those exhibits are available on the MSD website? Do you know?
Yes, they are. The
Okay.
entire consent decree is plus the exhibits.
Okay, fantastic. So really, there's a lot of material there, and it can probably seem daunting because it's a very large document. In the whatever PDF software you have, that will kind of, hopefully there's some bookmarks in there, whatever PDF viewer you use, that will show you how a quick way to get to the exhibits, the 6, 7, and 8 there that are.
Matt, if I could interrupt a second, just so you know, the exhibits are listed as a separate item on the website. And so when you open that up, the exhibits, the individual exhibits are listed on the left. So all you do is click on it and it'll take you directly to that specific exhibit.
Okay. Well, that's helpful. So you what you're going to be looking for is Exhibit 6, Exhibit 7, and Exhibit 8. Those are the primary exhibits that are going to, those are the documents that are really going to guide you if you're interested. And I would encourage people to read those because they contain a lot of information. Those are like I said, those are the documents that are, they establish the authority for this. They're the documents that the court continues to look at, that our office looks at, and I suspect that MSD regularly reviews to also, know what the specific roles and responsibilities are. So I don't have a whole presentation planned, but I can kind of go through more about what specifically to expect when you have an SBU event. So, let's say, for example, you have some water in your basement. You come home, you realize that there is water in your basement, and you suspect that it is backflow from the public sewer line. The first thing you're going to do is report that to MSD. There is a variety of ways you can do that. There's a phone number that is, and Tom has that number, I believe. He could probably put that in the chat, that you can call. I believe you can also report a backup online as well. There's a way to actually report this on the MSD website. Tom, I'm sure, can also provide the link for that. And it asks you a series of questions. I've done a couple tests with it. You go through, you enter your address, I believe, and there's a couple other questions they'll ask you to make sure that you are, that they have an understanding of what it is that, is actually happening at the property. After you've reported that, MSD will come out and investigate and determine if there is if it is actually a backup event, if it's from the main sewer lateral or main sewer line, if it's actually into the sewer lateral and into the building, or if it's something else. And we'll advise you accordingly if it is in fact a backup event. I do want to mention that there is, the consent decree itself has a restriction on what the timeline is on this. So you, for a long time, you had to be reported within 24 hours of discovery. So it's very important that people do that quickly. That has since been changed, as some of you may know, with the consent of all the other parties, involved in the lawsuit to 48 hours. So it is now 48 hours. And the reason behind that is some of it is basically spoliation of evidence. You got to have it in there. The MSD's got to know about this in order for them to come out and investigate. There's been some, there's been some discontent, I should say, with the fact that sometimes could be used as a what I would call a shield. But really, what it was designed to do, from my understanding, and I was not around when the consent decree was entered into, was really to make sure that reporting was done promptly and that there was the ability for MSD to come out and investigate and make their good faith determination as to what the cause of the water was. Like I said, that 24-hour rule has now been made into a 48-hour rule. So, as long as you are reporting it within 48 hours of discovery, you will be good to go as far as that restriction in the consent decree itself. So you've got this water and you've got this backup issue, and you've reported it. MSD will send someone out to investigate, and then will advise you as to what whether or not it is in fact covered under SBU or not. That's going to be the first step. I'm actually going to ask, so Tom, can you speak a little bit as to what a homeowner would expect when they report a water and basement event, and what happens when the crew comes out, they investigate? There's usually, I know during COVID especially, there were hangers that were put on doorknobs that advise the homeowner or property owner as to what the next steps are. Can you speak a little bit as to what that process looks like internally from MSD?
Sure. We, when we get the call, we dispatch a crew, one of our customer service crews. They go, they investigate, they check the main line, see if there's signs of surcharging or if it's currently surcharging. And before COVID, they would go into the homes. During the pandemic, we've limited contact for our employees and the customers. They do not go into the homes now to document what happened. We hope to eventually return to that, but customers can submit photos or anything they have of the sign. And then once they make their initial findings, preliminary findings out in the field, there is a plastic bag that they will hang on the door or give the customer at their home. And it has various forms in there, some just general information of sewer backups, and there's a very important field form that they give, and that field form summarizes their findings and next actions. It may be that MSD may provide cleaning services, which I'm sure you'll get into, or that it recommends they contact a plumber because it doesn't appear to be an MSD related issue. And so whatever the various determinations are, they will get a field form, and it has the work order number on it and contact information about who to contact regarding the next steps. So there's all this information. It comes in a plastic bag that will be typically attached to the doorknob, stuck under a doormat or wherever they can do it. So if you're not home when the crew comes out there, it's important to look for that information when you do get home.
And I'm going to ask you a follow-up question, Tom. Is the details on how to file a claim, are those included in that initial packet?
Yes, there is. There is a card that has the claim information on there.
Okay. So if you're a homeowner and you've got water in your basement, you've called MSD, they've come out, they've done their investigation. The next step in the process would be filing a claim directly with MSD for the damages that you believe that MSD should be responsible for. There are, and like I said at the outset, I'm not providing specific legal advice here. I am not in a attorney role here, so I will speak broadly to the specifics on how you would prove up your claim. What you're going to want to most likely want to do is provide as much evidence and material as part of that claims process as you can. You're going to want to show the costs, estimates, pictures, things of that nature. Think of it generally as, the analogy I sometimes use is like you're an insurance adjuster. Like what your job is to find out, what it is that you think is necessary to compensate you, to make you whole for the damages that are done. That's part of the claims process. You want to do that early and do it from the outset. There's a couple of different ways, and one of these I believe is fairly new, to file your claim. You can do it on paper, the old-fashioned way, but there's also, MSD is also now accepting claims via an email address. I believe, I know I have the email address written down, but I don't have it in front of me. Tom, do you know what the email address is that all of the claims are going through?
Yes, I'm in the process of typing that into the chat.
Okay.
I typed slow though, be patient.
Yeah, sure. Yeah, so there is, this is one of the things that the Ombudsman's office was kind of pushing for a while, was getting an email address established so that people can submit claims electronically. Attach PDFs to that. I mean, that's the that's sort of the way the world is headed, and the ability for somebody to do that, not have to print everything out and then mail it in, we think is definitely more efficient, and is definitely a good step forward. So that is something that, yeah, there it is. It's SBU claims at cincinnati-ohio.gov. And this is in the chat feature here. We can provide this information after our larger presentation here, so that everybody can have that and see that. So we're going back to our example. Homeowner makes the claim. MSD responds and says, they could say a couple of things. One is, we don't believe this to be a compensatable event. They could say, okay, it's maybe compensatable, or this is something that we'll cover, but this is the value that we think is appropriate, and offer compensation, and it may not be what the homeowner thinks is appropriate. So if one of those two things happens, the next step the property owner can take is filing a request to review in federal court. And that's usually when we, the Ombudsman's office, get involved. So we will have calls from people who disagree with the decision that MSD made, and they have a right to request a review before Magistrate Likovitz in the Southern District of Ohio in federal court. This is the same court that established the consent decree in this lawsuit. It's all part of the same lawsuit at large. And there's a couple of forms to fill out that our office provides in the event that a property owner or tenant or whomever wishes to dispute MSD's response to an SBU claim. Those forms are also available on the MSD website, and we also provide those. But once you get to that stage, so you've had your event, you've called MSD to come out, and they come out in there to make a good faith determination as to the cause. You filed your claim with MSD directly, and then if there's still a disagreement about that claim, then you're in the right to review before federal court. That process is designed to be as close to a small claims process, from what I understand, as possible. So it is designed to be somewhat informal. You're still in court. It's still an official hearing, but it is really set up so that a property owner or a tenant or whomever who has a claim, they can make their case without it being too formal, too lawyerly, if you will. It is really designed to be, friendly to the what are called pro se. That means somebody without an attorney. It's designed to be friendly to that. But like I said, it's still a court proceeding. So there's some ground rules you're going to want to keep in mind. You still have to make your case. You still have to prove your case. That can look like a lot of different things. You're going to have to bring evidence with you. You're going to have to be able to prove what your damages are. If it's a causation issue, you're going to have to be able to prove that prove your case that you think that this was actually caused by MSD or was in fact a backup from the main sewer lateral, an actual SBU event, as opposed to a slow drain or something like that. So that's something to keep in mind, is that it's on you. The burden will be on the person filing the claim that's what they have to prove, and that can look like a lot of different things. It can look like estimates. It can look like bills or repair. It can actually be bills, or it can be estimates. It could be you're gonna want to have photographs. You're gonna want to print those off. In most courts that I deal with, everybody has a phone now, and most people take pictures on their phone, and then they bring it into court. And if they don't know better, they'll ask the judge essentially just to look at the phone. Most judges that I practice in front of, that's not allowed unless the phone stays in evidence, because it has to be part of the record. Unless the phone is going to be kept for months and months by the court, you're not going to. The judge a lot of times actually won't even look at it. I have heard recently that Judge or Magistrate Likovitz will examine phones on occasion. I think it's by far a better practice to print off, photographs of anything you want to show, anything you really want in the record, anything you want to try to establish, to prove your case, anything that you think is evidence. You're going to need to be able to leave that with the court. You're going to want to print that out and take it in and leave that. There's probably the ability to mark exhibits if necessary, but those all, if they're going to be part of the record, they got to stay with the court. So that's something to keep in mind. And you're really going to want to think of that, the case that you're making. You're really going to want to try to think of yourself as, like I said earlier, almost like an insurance adjuster, right? You really need to be able to be thinking of this. Okay, how do I prove what the value of this is? And you can, do that in a number of ways, but prove the value of it. So if causation is established, all you're really talking about is value. If what you're challenging is the determination MSD made, you're going to want to think of resources on how to challenge that causation, right? So that's really what you need to start to think of, is that may look like a plumber, that may look like an engineer, could be a lot of different things. But that's what you are challenging. You really need to think of it as, how do I prove what I think happened is true? And that could look like, like I said, it could look like a lot of things, but that's the best way to approach that. It is to think as analytically as you can and show up with evidence that's printed out that you can actually provide to the court. So that at that point, the judge would make a determination, and you would find out what the decision is at that point. So that's an overview of the process. A typical process. I know there's some questions, or there's some thoughts about prevention. So I'll speak briefly to the prevention issue. That is, I'm looking at it now. I believe that's Exhibit 6, the prevention itself. Yes, it is Exhibit 6. So the prevention is outlined in the parameters of that program. The prevention program are outlined in Exhibit 6. There are a couple of pages here, and I would strongly encourage people to look at that because it talks about different things that can be asked of the property owner, and it also talks about different ways you can try to get it considered for prevention. One of the I know MSD will call, and I'm going to actually defer to Tom a little bit on what the internal MSD parameters are for when they think and they want to proactively reach out to a property owner about prevention. But I will highlight, the bottom of page 6 says that anybody can call and ask to be evaluated. There is I believe it's the same phone number. Yeah, the 352-4900. So that is the same phone number. If a property owner believes that they should have a prevention program, should be considered for the prevention program, they can call. They don't have to wait around. So I would encourage people who believe they should be considered to be proactive about it. There's also a number of attachments and pictures there that kind of show and outline what prevention looks like. I think that's useful for folks also in considering what the steps of a prevention device or what a prevention device would look like. But at this point, I'm going to ask Tom Frank with MSD to speak a little bit about the internal decisions that MSD or internal criteria MSD might look at when they are considering a prevention, considering a property for prevention.
Sure, thanks, Matt. As in the consent decree in that exhibit, one of the qualifications is a property that has, it says multiple capacity related backups within a 5-year period. Yes. So one of the ways we sort of monitor that is when a work order is created, when our crews go out and do their preliminary investigation that we talked about briefly before, and it's determined that it's a capacity related backup, it is immediately referred for an initial preview by the SBU prevention program. And they will look at it and determine at that point if it may possibly be a candidate for the program. Basically, if you've had other backups within that 5 years, capacity related backups. And at that point, we will reach out to the customer to see if they're interested in the program. So that's one of the ways they get into the program. The other way, obviously, is if a customer reaches out to us. No matter how many capacity related backups that property may have had, if a customer asks us to apply to the program, they will be given a questionnaire to fill out, which we call it a questionnaire. Essentially, it's the application to the program. And then we will do the review on it to see if it meets the terms of the eligibility. So those are the two ways. Either a customer can contact us, or if we have found that they've had a capacity related backup, we will do a review. And if it looks like they've had multiple backups, or there's a couple other possibly qualifying conditions without actually having the 2 backups, we would reach out to them. So those are the 2 ways that properties typically get into the program.
I'm going to ask you one kind of follow-up question, Tom, and that's about backflow preventers versus pumping systems. I know those are outlined in the consent decree. Are you using, is your department using both of those, or is it kind of dependent on the way the property is constructed, or how does that determination work?
Yeah, we have engineering firms that do the design for us. And so they will go into a property and do a complete investigation of the plumbing of the property. They map out everything through dye testing and camera work, and then they determine what's the best solution. Primarily, we use the pumping. The backflow valves can be used in some occasions, but just without getting too technical, it really depends on the layout of the property and the amount of surcharge that they're experiencing. Obviously, a pump is sort of a beefier version that will protect the property better than just a backflow valve. And both systems have pluses or minuses, so they try to find the solution that best fits the property.
Okay. So I do want to, I also want to point out one of the terms, I believe this is in the consent decree here, that talks about things that can be required of the homeowner. And one of those is, and I know we've had a couple of calls to our office about this, it can be asked, a homeowner can be asked to disconnect the downspouts on their property. So there's some inflow sources that may have to be, and this is also this is in the consent decree, may have to be removed so that, you know, for example, if your gutters are going into your sewer lateral, there you may be required to disconnect those gutters and daylight those out. So put those out in the yard or do something else with the gutter. Cincinnati has older housing stock, and so I know that there are many properties around town that have gutters or rainwater that go into their sewer lateral that there may be a request made prior to any sort of prevention that be remedied before prevention would be put in. So at this point, I think I'm going to turn it back over to our moderators and see if there's any questions as to the specifics that I mentioned, or if we're ready to move on to the next portion of the evening.
Mr. Fitzsimmons?
Yes.
Mr. Fitzsimmons and Mr. Fong, I hope I'm pronouncing that correctly, but I just want to alert you, you're down to 10 minutes. You have 10 minutes remaining. Thank you.
Okay, thank you.
So, Matt, before we get into questions, would you just sort of outline what qualifies people for the sewer backup program, the response program, and then what is MSD supposed to do with a qualified complaint?
So what qualifies someone to have to actually have MSD come out?
What qualifies them to be entitled to file a claim and get damages?
Sure. So if there's a capacity.
Oh, sorry about that. I meant to mute myself and I muted you.
No, it's okay. So if there's a capacity related issue, how this, Tom's going to know I'm not an engineer, so Tom's going to know the engineering better than I would. But when there's a capacity related issue at the municipal side, so at the street side of a sewer, and that capacity issue, meaning that there's too much water coming into the sewer system for that sewer that sewer main to handle it, it will back up, and as a result of that, basically being filled up with the sewage or rain discharge, whatever it may be, it will back up in, fill that main sewer pipe up, and then we'll start to fill up the laterals that are going into the individual houses or properties. And once that happens, once it gets up into the basement side, then you will have water coming into the basement from the main floor, usually the floor drain. It can come in a couple different places. I believe most of it is the floor, going to be coming up through the floor drain. But you'll have water actually entering the basement through that floor drain. That is the type of backup we're talking about here. That's the capacity related issue that we're talking about. That would qualify somebody for some relief here. And I don't know if Tom wants to add anything to that, but that was my sort of layman explanation of what happens.
No, that pretty well summarized the capacity, but I did want to add that it also qualifying would be for anything that happens within our system, say a sewer collapse, failure, blockage. So it's not just capacity related as far as a claim. So if we have a sewer break out in the public sewer that causes backup that leads to backups in the homes, those would also be eligible. If we had a root blockage or grease blockage, anything that's similar that can happen on a private building sewer, if that happens within the public sewer, we would also pay for damages through the claims process.
And I will add, it is an important distinction because we do get calls on this, and you know, it is not intended to anybody that has water in their basement. It's not that is not the aim of the program, and that's quite clear in the consent decree. You know, sometimes homeowners are responsible for their own sewer laterals when it's on their property, right? And you know, sometimes people, you know, roots. You'll have a tree in the front yard and roots will interfere with your own tile sewer lateral. Or if you've got a backup situation that's happening, you know, we've sometimes gotten calls where people say, well, when I do the washing, if I run the dishwasher and I take a shower, and as soon as I do the laundry, all of a sudden I've got suds coming out of my drain in my basement. It's been dry for 2 weeks. There's been no rain. You know, there are different situations in which the homeowner may be responsible for some of this. The program isn't designed to cover everything. It is designed to cover, you know, the MSD responsible. If it's something that MSD has done, that's what it's designed to do.
Thank you. One thing I'd like to add on that, and once again, Matt, you explained that stuff perfectly clear, but we do want to encourage everybody to call MSD, report a backup when you have one, even if, like in that scenario, it's been dry, because there is still a chance that there's something like a blockage or something in our main. So we will come out and investigate, and we want that opportunity to verify whether our main is working properly, if it's functioning. And that at that point, one of the field forms that you would get would be that advise you to contact the plumber if we found our line is open. But I always try to encourage people before they go through the expense of hiring a plumber, assuming it's their responsibility, call us and allow us to come out and verify that there's nothing going on with the public sewer before you go through that added expense of contacting a plumber.
Mr. Fromm, Mr. Fitzsimmons, we're down to 4 minutes and 6 seconds.
Okay, thank you.
Thank you.
I would also add, just so that hopefully this, you know, something that's contained in the consent decree is that MSD is responsible for making a good faith engineering determination. They are, that is what they're charged with doing, is coming out and making an assessment that is, you know, honest. I don't want people to think that, you know, MSD. I want it to be clear that that is what's contained in the consent decree itself. That is what they're charged with doing, you know, that's what's in there. Allison, did you have a second question? I don't know if I answered. I know it was a two-parter. Did I answer both parts of that, or did we address both parts?
So once someone is qualified, then what is MSD supposed to do according to the consent decree?
At that point, they file a claim. The homeowner would file a claim. They would, after they've done the reporting, and after there is some, you know, that there is that triggering event, that 24 and out 48 hour report that has to be done under the terms of the consent decree itself. Once that's done, they can then file their claim, and they can do that, like we said, one of two ways. You can do it on paper, snail mail, or drop it off. And now there's the ability to do that via email.
Okay, this is Florence. I guess we're ready to open questions from the attendees. So we would like to prioritize questions from anyone who has had a sewer backup, and we want to get to everyone's questions. So we will ask that you keep your questions, comments, and responses direct and concise, limited to 2 to 3 minutes each. If you've already asked a question, please give other people a chance to speak before you ask another. We will begin with questions from the chat. And Marie, are there questions in the chat?
Yes, there certainly are. There's a question from Ella Thomas who says, what is being done for overland flooding? Because that's the user response from MSD. Also, how is it determined who gets the sewer backup device? And then finally, are you looking into other options than the big silver dish that goes in the front yard of the homeowner? I guess that
So,
was-
and just so you all know, Ella's got her hand raised as well. So if Ella, you would talk about those questions, you certainly can unmute.
Oh, thank you. Thank you, everyone. And thank you for being here and explaining the process. And just like the questions there, and I know you also made a question, you made a statement about the roots that is property owners, if roots are coming into the pipes, but we can't, the property owners can't touch the trees or do anything if it's because that's city property. And so we will get fined if we touch that. So again, you know, that's putting back on the property owner, but again, it's a city problem. Can you explain that or expound on that, please?
Well, I can certainly take a stab. I do want to say before we get into too many questions here, you know, there is a question and answer portion of this. I have, as an attorney, though I am not here in an attorney capacity, I am prohibited from answering specific questions as to a person's specific circumstance. So I can speak generally to the questions, and I don't think this first question is specific. But I want to put that disclaimer out there so that everybody's aware that if you say, well, what should I do personally? That is something that I'm not going to address. I can't address. I will say, so, you know, homeowners are responsible for the lateral portion. I'm not an engineer. I'm an attorney by trade. My understanding is that there are ways to cut roots from sewer laterals that don't necessarily harm the tree, but homeowners are responsible for their sewer lateral up to the line there. And Tom can speak a little bit to what the exact parameters are, and probably even speak a little bit to possible cures for tree root intrusion into sewer laterals.
Thanks, Matt. Yeah, just to clarify, the building sewer or lateral is the pipe that runs from your house all the way to the point it connects with the public sewer. So that entire length, even the part out in the right of way, is owned by the property owner. So the property owner is therefore responsible for maintenance of that pipe, keeping it clear of debris, such as roots and grease and those kind of things. If there's a structural problem in the building sewer, in the right of way, out in the public street, MSD will fix it. It's built into the rate structures, even though they don't own it. It's a public service and a safety issue, so we don't have property owners trying to dig in the right of way with utilities and street restoration and all those things. MSD does that. They are not responsible for damages caused by that privately owned pipe that may have caused a backup into the property. As far as the roots, I will be perfectly honest with you. That is a challenging situation that a tree that you do not own or a person does not own gets into their privately owned pipe. There is root cutting that plumbers can do. There is lining, which they can put this cured in place liner that will seal any joints and loose cracks that allow roots to get in. Obviously, none of those are extremely cheap. The other option you have, and it depends on where you live, but if you're in the city of Cincinnati, and I know they have a very strong urban forestry and we all love trees, but with my background, I'm not a big fan of trees out by the sewers. They will be willing to discuss having that tree removed if you can prove that it is causing damage to, say, your sewer pipe. I don't believe it's an easy process, but it is a conversation that's definitely worth having with Cincinnati's urban forestry if they're the owners of that tree, which would be those trees that are out in the public right of way, typically between the sidewalk and the street if there's a sod strip out there. That's the only remedy I know for a possible way of having a tree actually removed if it's been causing root problems.
So we
Can I say something?
another questions
Yes, ma'am. Yes.
in the chat?
Oh, yeah, the other part of the question was, how is it determined who gets the sewer backup device?
Okay. Matt, you want me to take that one?
Sure.
Sure. As we talked about previously a little bit, and this may have been put in the chat before we discuss this, but if you want more information, let me know. It's based on the qualifications requirements in the consent decree, which is multiple capacity related backups within a 5-year period.
Okay, thank you. Now, next
Yeah,
chat.
and there's a couple, the first question that Ella had was also about overland flooding and, basically what to do about that. And another question related is that, what about an incident of overland flooding due to a clogged sewer drain on a neighbor's property? Any comments on that?
So I'll apologize. This is the second question that we're referring to by Jean or Janine?
Jean Nightingale, huh?
Okay. So I guess, I mean, I would need probably, so the question is the overland flooding coming from a neighbor who has like a downspout or some other, I guess I'm trying to envision a scenario in which a neighbor's sewer drain is high enough up that it's causing overland flooding into the basement of a neighboring.
It's uphill. It's coming down on the hill and going into my kitchen when it gets clogged up with leaves in a parking lot.
Okay. I'll be honest with you. My initial take on a situation like that, I mean, like I said, I can't address specifics, but if there is there are legal responsibilities that neighbors have to one another that might be something somebody in your situation would consider exploring. I'm not sure that's really an MSD issue. That might be a neighbor issue. That based on the hypothetical of somebody's water coming across a property line and causing some sort of damage on the neighboring property. Yeah, that's sort of a vague answer, I know, but I don't know if Tom has anything he wants to add to that.
The only thing I can tell you is the appropriate authority would be the building department on a situation like that, where it's one property owner it's a maintenance issue from one property owner that's affecting another one, is something that whichever local jurisdiction you're in, the building department would have some authority over that. MSD would not have any authority whatsoever over that. There's really nothing that we would be able to do.
Okay, thank you.
So Florence, I just want to let you know, we got a couple people in the Zoom with hands raised, and maybe we can go to them and then go back to the chat. So we've got Edgar and Alondra.
Okay, Alondra?
Yes, hi. I have a question about, I had 2 sewer backups that were coming from my basement drain. I had about maybe 4 feet of water, and MSD came out and they they put fans in to dry out things. However, I have the water lines on my wall still, and I was told, or I was talking to someone, I believe it was Allison, and that those walls should have been torn down. I'm not sure how, is that correct? One, that's my first question. And how long after the incident do you have to file a claim? Because like I said, I had back-to-back within 2 weeks. And I personally paid for my furnace, and now 2 weeks later, another incident where the sewer backed up again. And now my street is actually on routine maintenance clean.
Oh, gee.
Okay. Well, so I can answer, I hopefully can answer some of the first part of that with, documentation is going to be your friend in any of these circumstances. So if you were informed by somebody, and it may have been a contractor, I don't know, written estimates, anything you can do to document that being the appropriate remedy or the appropriate course of action, you're going to want to, I know it's hard if you've just experienced a backup and there's a lot going on and you might not be thinking in this way when you are experiencing one of these. And so it can be a little difficult to remember, I got to take pictures. I got to have, things put in writing. If somebody's telling me something, if I have a contractor out and they say something, remembering to try to get it in writing. Sometimes you can go back and ask. That's always going to be a good idea, but you're going to want to be really thinking about documentation, as early as you can remember to think of it. If this is going to be something that comes up. So, if someone tells you that there's an appropriate remedy that they think is best, and it's a professional, it's a workman, it's a contractor, whomever, get it in writing as part of an estimate is really what you're going to want to do.
Okay, Edgar?
Yes, my name is Edgar Russell. I'm happy to be here. This is a hard subject for me. I know Tom personally. I don't know if he remembers me, but we dealt a couple times. On May 29th, 2014, I have a pretty good sized house. My basement could probably fit three apartments in there. I come home to 5 feet of water in my basement and my garage. I've been in this house approximately 57 years, never had nothing like this at all. What was happening, the water was coming down Red Bank Road, and the sewer that they have on the street could not handle the water, so it came up into my house, my next door neighbor house, and the neighbor next to it. Now, my front yard is approximately 65 yards to the street. My main clean out was up near my house at that time. I did everything Tom asked me to do. I went out and got estimates. I got the lowest value, depreciation value. Sent it back to them. They denied the claim. They sent professionals out here. They never found anything. Okay, I even turned my downspout and turned them towards the yard. Then we ended up in Supreme Court. Tom, when I first met him, he said, "Oh, it's our fault. We're going to take care of everything." Then when it came time for support, they flipped the script. If the SBU program would work the way it was designed, it'd be a beautiful thing. They didn't even put a backflow in my yard for me. All they did was came out and moved my main closer to the street, which gives me more responsibility. That's the only thing I got out of that. I lost about 97,000. Can I finish, please? I lost approximately about $97,000. My question is, I was on TV for a month. They ran a whole course on my house for a whole month with Channel 9. Talking about homeowner done wrong. But the point I'm getting at, if MSD and SBU really want to help you, after all this, I lost everything. By the grace of God, I'm still here. They never showed me how to fix a problem if it was my problem. We've never had a flood since then. It was the city's fault. But once you go to that Supreme Court and the judge claims against you, there's nothing else you can do. what can a homeowner do after that?
Right.
Nothing.
We're down to 30 seconds.
So,
I asked,
yeah.
Oh my God.
go ahead.
Sorry.
Go ahead,
Yeah.
sir.
I don't know a lot about your specific situation. So if you want to, I'd encourage you to call our office. I don't have our entire roster here. Did you call the ombudsman's office at some point, or is this?
I came down through you guys, and that's how I ended up in. After this, I went through all 3 levels of denial, and then I came through the ombudsman, and that's when I got referred to Supreme Court. And I went to the Potter's house. I forget the judge's name. She did not tell us at the court date whether we were approved or not. She just mailed out a thing saying, "Hey, claim denied." That's all I got. You know, and it's such a nightmare. I just let it go.
Yeah.
In the federal court.
So I just wanted to make sure I understood. You said Supreme Court a couple of times. So you only did the right to review process. You didn't. There was not a separate state court suit that you would file with an attorney.
I did not have an attorney.
Okay. I tell you what. If you want to message me after this, I don't know if the ombudsman's office can kind of look into it. I'm happy to take your name down, and I can connect with Allison on getting.
All right, I have to go to work soon. Is it possible you can take my name and number down? I work 3rd shift, you know, but I wanted to be here.
Is it okay if I follow up with Mr. Fitzsimmons with your information?
Yes, ma'am, it is. You know,
Okay.
whether I get any relief or not, don't want this to happen to the next person.
Yeah. So I will sort of speak generally, and I don't want to. I'm not trying to cut Tom off, and I don't know what he may remember. This particular avenue for relief is designed to make it more accessible to homeowners. There are other avenues of relief, and it can get a little tricky. If there was a different type of claim, you're not required to follow this to a point. You're not required to follow this particular avenue. Things can it gets a little tricky because you're dealing with a government agency. And so generally, if you want to pursue claims in a different forum, that's when you're maybe looking at potentially talking to an attorney about it, because it can get a little dicey for homeowners. But I'm happy to I'll connect with Allison, and maybe, you can connect to the ombudsman's office after this. I don't know if Tom wants to say anything on this issue, or if in the interest of time, we want to move on.
I think we should move on for more in the chat.
Yeah, Florence, I'd like to mention that Allison mentioned this in the beginning, but somebody in the chat is saying that we should mute yourself if you're not speaking, because there is a lot of background noise.
Oh,
so that's the news in the chat. And I would like to say there's kind of some editorial questions about proof. There's one question about what kind of proof would you need for an entire street that's been flooding for 50 years? And then the issue of having the homeowner having to prove the burden of proof lies with the homeowner, and then clearly, as we've seen, MSD can refuse it and put it on the homeowner. So those are a couple of questions about proof. I don't know if Tom or Matt, if you think you've answered those adequately.
I think everybody said that I have, and probably everybody else does.
Yeah, I mean, I can, I guess, speak back to the proof issue a little. I mean, I'll limit my answer. Let's say this to damages, and this is going to be true with just about any court that I've ever been involved in. If you're asking for a particular level or dollar amount, it is going to be on you to prove that that is what you are entitled to. courts are not going to accept blanket statements as to what someone thinks that they are entitled to. And that can look like a lot of different things. Like I said, I mean, it could be estimates, it could be, insurance adjuster statements. There's a lot of different ways. I don't want to limit it. It can certainly be many different things, but actually showing the value of things is imperative, and that's true in any judicial forum.
I have another question here in the chat that is asking what engineering firms are used. The engineering firms that you that I think it was Tom that said were sent out.
Yeah, there's several of them. I mean, one is called Stantec, one is HDR. There's an environmental engineering. And I don't work with the program directly. I'm trying to think. I think there's a fourth one off the top of my head. I can't remember what it is, but I can get those if anybody wants them. They're 4 very well-known, reputable engineering firms. A couple of them been working on the program for, I think 1 or 2 have been working since the start of the program back in 2004.
And
so Florence, we have Sheila has her hand raised in the Zoom. Sheila, do you want to unmute?
Thank you. I wanted to say that you had mentioned the dollar amount, how we had to prove the dollar amount. I went to the ombudsman and filed a claim and went to court. I had lost furniture, electronics, and appliances, as well as clothes. And I was ruled against by the magistrate. However, my next door neighbor was approved, and all that they were requesting was reimbursement for getting their water heater repaired. So I wanted to know, I had pictures, and also the people who came and cleaned out the house took pictures. So I don't know what else I could have done to help this case. Can you provide any information or any help with that?
Yeah, I mean, like I said, I can't really speak to the specifics of your individual case, but I can, I guess, speak generally to how you would prove it. There are different ways. So there's going to be different types of denials. There's going to be causation. There may be a dispute over the actual damage level, but proving those are going to look different. So with causation, you're going to need to be able to prove that the damage, essentially that the water in your basement was in fact an MSD issue, and that's going to look different. It's going to be more technical. There's going to be engineering reports, things like that are going to be necessary. That's different than a dispute that's only about damages. So when you're talking about damages, that's where photographs, that's where estimates, that's where different things that show value are going to come into the equation.
Okay, I see. What was said was that the sewer wasn't the issue. However, like I mentioned, my very next door neighbor had a claim and they were approved, so they were saying that we were on different drains, and it just didn't make sense. I felt like the amount that I was asking for was the issue.
Okay, so I mean, I can tell you that it's going to be a threshold question. Responsibility, that's the first question that's going to be addressed by the court is, ultimately, is this an MSD caused issue or not? And if it's not, that's the end of the inquiry. If it is, that's when you're going to get into the damages question. So it's a two-step process. You got to answer affirmatively to the first question before you get into the second question. As to what your neighbor had, I can't really speak to that. I don't know if Tom wants to elaborate on why neighbors may have different experiences with sewer backups, and if there's anything in construction or in the engineering side that would explain that. But like I said, that when the judge is looking at it, that's the initial inquiry. That's how it's going to look, is that initial question followed by the damages second.
Okay.
Yeah, just if I can just expound briefly on that. There's various reasons why one property may get a settlement offer and the other doesn't. Like I said, and that is a technical evaluation. Maybe there's difference in elevations. I would be more than willing to just look at this in detail on the side and talk with you, Miss Sheila, I guess it is. My contact information is in the chat line. My phone number and my email. If you want to reach out to me, I will research it and try to figure out what was going on and see if I can explain it to you. One of the things, excuse me, one of the things that's really important to understand as far as the valuation of claims is the difference between real property and personal property. Real property is, I always tell you, it's the stuff that stays with the house, and the personal property is the stuff you take with you when you move. So the real property, like if your basement's finished, the carpeting, the walls, the hot water heater, the furnace, those kind of things are paid at replacement value. So for example, a claim that only has a hot water heater, you provide a receipt for your plumber to install this hot water heater, and that's the amount you're going to be, if it's determined to be an MSD responsibility, that's the amount you're going to be offered. Real personal property is depreciated value. So, and that's where a lot of people have concerns with the amount offered because it's depreciated, it's not replacement value. So those are the two main categories that help determine the amount of the offer. And as Matt has mentioned repeatedly about documenting, the way I always describe it to the customers is the more information you can provide MSD about the items you've lost, the better chance we are going to be able to provide you with a number that you're going to be pleased with. Because the more we have to make sure to do due diligence to protect the ratepayers' money, we have to make sure we're trying to fairly evaluate that property loss. So the more information we get, the better it is for you, the more we'll be able to come up with an accurate number.
Okay, Kevin Colley, I mean, he's had his hand up. Kevin, you're muted. Okay.
All right, so my question would be, how would one evaluate or value loss of use of property? So I've literally just now gotten this fix over a year and a half of complete loss of use of my personal home and loss of use of revenue of possible rental income. Not to mention the amount of damage that's been done to the basement. How would I value the property damage? And also, how would I back flag? Because I have 3 affidavits from master certified plumbers in Ohio that say it's in the MSD's right of way, and they've refused to do it. I literally had to go out of state to get an excavator to fix this.
So, Kevin, I'd be happy to talk with you. It sounds like you've got a pretty specific question.
Yeah, I've contacted the ombudsman office. I don't even know how many times.
Okay.
And literally at this point, I'm left with no choice but to go to the Supreme Court or go to the federal court.
Okay. Well, I'll tell you what, I'll look into it. I don't know if you know, you've spoken with me or who you might remember who you talked with. But I'd be happy to.
I've never actually talked with anyone. I've probably 20 voicemails.
Okay. Well, I can tell you, I mean, I'll look at it.
This is primarily in 2018 and 2019. The house has been unusable since January 2019 or 2020.
Okay.
Okay, now we're back to the chat.
Yes, well, we do have a question which maybe we talked a little bit about before about the trees, and the question is, why would a property owner be responsible for a tree not on their property? Maybe.
I mean, I don't want to pontificate on what the law may be on responsibility, but I can tell you that it does vary from state to state. I don't know if anybody remembers a couple of years back, there was a special done by one of the local news outlets, and it talked about in Kentucky how the way the law works is that the sewer lines are the homeowner's responsibility. I think it's all the way to connecting into the underneath the street. And so this news story went around and took photographs of people who had, I think, attempted their own repairs, and it basically like dug up the street, or there was some major water erosion problems on the street where the property owner's sewer lateral connecting all the way to the street was an issue. And the local sewer district in this part of Kentucky was not, and the road engineers were not stopping anybody from doing it this way because they were ultimately responsible. That's really the answer, I think, to that question, is that, hooking into the sewer lateral, there's going to be different rights and responsibilities based on the jurisdiction that you're in. And that's just how it runs here. That's just how it is here.
There's another question.
It's a little bit like, if I may, I'm sorry to cut you off. I mean, one of the things we learn in law school is about trees. Trees are not dissimilar, right? It's the different states have different rules about your property line. Are you allowed to cut a tree that's overhanging a property line straight up, like as if your property line went up into the sky completely straight? Can you just cut off every branch that is overhanging your property? Different states have different rules on that. And it gets a little tricky sometimes with property lines and rights and responsibilities.
Okay, we need to move on. More questions from the chat?
Right. There's another question about, let me find it. What about capacity for CSO overflow, creating overland flooding of sewage?
So I can tell you that that is an issue that has come up. It is, I don't think there's a clear answer. Tom may disagree with that. I don't know, but this was the issue that happened in Northside a couple summers ago, is that there was a flooding issue that happened. And I'll be honest with you, I was on the team at the time, but I was not full-time on the Ombudsman's office, so I don't remember all the details on it, but I know that this is something that's come up, and I don't believe there's not a clear-cut answer to that.
Okay. Good.
We have another one, which maybe I might have missed it, but the question is, how long after an event has occurred and MSD came out to evaluate, how long of that time do you have to file a claim? In other words, you've contacted MSD, they've come out, then how long?
Apologize tomorrow.
So I believe it's 2 years, and I'm going to try to find the citation if I can here in the consent decree. It would be in Exhibit 8, just so that I can give everyone that citation.
I mean, in the meantime, we've got 10 more minutes for questions, so just to let everyone know.
Florence, did you want to just go to people in the Zoom to mute, unmute?
Has anyone else got questions in the Zoom?
And you'll have to unmute yourself.
I've got a few questions.
This is Kevin?
Yeah.
Okay.
Okay, so what about the responsibility of the actual employees The sad part is I'm actual city employee. I work for Fleet, but the city employees have come out and left hangers on my doors saying that they, it was homeowner's responsibility without actually inspecting anything. Literally 3 times this has happened. There's no access to any clean out except in my basement. So there was no way they could have accessed it. Secondly, there was no way they could have launched it from, the main camera, because I know that there's only one working truck in the city. And that one doesn't work most of the time.
I would disagree with that. There's only one working truck in the city, but we can, if you think that a crew is out and did not do the work.
No, there's only one.
If there's
mainline truck.
Please?
There's only one working mainline truck in the city, mainline camera.
There's
a ton of the other ones.
This is what they would do is they would launch it up, but those crews that go out to respond to a sewer backup do not have that equipment. They are not TV crews. That's a separate crew.
I'm aware, but they've actually left the homeowner's responsibility hangers on my door without actually inspecting anything. This has happened 3 times.
What they would have inspected is the manholes on the public sewer to find out if there's an issue within the public sewer. What I was going to say is, if you believe a crew was out there and did not do what they tell you to do, call that 352-4900 and ask to talk to a supervisor. They will put you in contact with a supervisor, or you can call me, because the process is when the crew is out, they respond, they're required to take photographs of those manholes that they're checking. Everything is done on a tablet.
I hate to interrupt this, but maybe Kevin, you should call Mr. Frank directly, and get more detailed with him, because we got other questions that we'd like to get to.
Sure.
Okay. Well, thank you both. Anyone else has some questions in Zoom? You have to unmute yourself before you ask your question.
Alondra's got her hand raised here
Alondra?
again too.
Okay. Alondra, you have to unmute yourself, please.
Okay, I'm sorry, but I think I put both. I put the question in Zoom and I raised my hand. But I kind of agree with the young man who just spoke. I was told, like I said, I had back-to-back sewage floodage in my basement. And one crew said, oh yeah, the main line was backed up with baby wipes and grease from up the street. So by the time I live at the end of the street, it could not flow through. So then 2 weeks later, they said it's my fault. Like, you need to call a ton of people. And I'm like, I don't know. And I was told that I did not qualify for a sub pump. But then now, like I said before, my street is on a routine maintenance clean. So what qualifies a street to get routine maintenance clean of the sewer lines?
Some of that is really specific to individual streets and sewers. I would be more than willing to look at it and discuss it with you if you want to reach out and contact me directly. My contact information was in the chat there. So I don't know, I obviously can't speak of the specifics at this point, but give me a call and I will be more than willing to discuss that with you and look into it for you, okay?
Okay, thank you, because I'm not the only one on my street that it happened to.
Do we have any more questions in the chat, please?
Just some comments. Here's a comment that Todd Portune said years ago that overland flooding would have to be covered by a separate grant or source of money. Do you know anything about that? Either one of you, Tom or?
Well, one thing, and Matt might want to chime in on this too. Overland, I'm not really sure what Commissioner Portune was speaking of at that particular time. It may have been after he made a few statements after the August 28th, 2016 rain event that may not have fully reflected the SBU program. Overland flooding is not part of the consent decree. Matt may want to address this. It actually specifically excludes overland flooding in those exhibits he's referenced.
Yeah.
And MSD doesn't really have the capabilities of dealing with overland flooding. It is, the consent decree is, particularly those exhibits, deal with capacity issues within the sewer. Matt?
So we only have 3 more minutes before I'm getting ready to close, so.
Yeah, I would echo what Tom said. I mean, the reason I encourage people to look at these exhibits is because they are controlling. What is contained in these exhibits, the court is bound to follow, as is MSD, as is everyone else. So Tom's right, it does, there is a limitation in there, and like it or not, that's what the court is bound to follow on what is contained in those exhibits themselves. So it's really important that people have access to that. And I understand they can be a little dense. They can be a little hard to, they're written sort of legalese. But those, like I said, those are the documents that are the most important for this program.
Okay, we might have one more question.
Yeah, there's nothing. There's nothing more in the chat, Florence. So maybe.
Okay. Anybody else have a short question? Because
Let me make a comment.
2 minutes.
Elder Ragley, for those who just spoke up and said that they didn't get any results, he just opened the door for y'all to contact him. Please contact him right away. Don't pass up this opportunity. Contact him while he's asking you to contact him, and then see what results you get from that. Thank you.
Okay. Well, thank you. I think that.
Have you seen my question?
Yeah, there's one last question from Denise.
Okay.
My question is, Denise, go ahead.
Has there been a civil lawsuit against MSD? Because I've seen lawsuits from businesses and how the city of Cincinnati and certain areas back in the early 90s, early to mid 90s, had a very poor construction of a pipeline for the water sewage. So I've seen that, and I've done my homework. So, but I haven't seen anything about a civil suit against Metropolitan Sewer District. Can you answer that question?
That is what this is. That's what this all comes out of.
That's what this is now?
That's what the consent decree comes from, is that the city was sued, MSD was sued in 2002, I believe it was 2002, about a variety of things. And there were a number of plaintiffs, the US EPA, the Ohio EPA, the Ohio River Valley Sanitation Commission. There's a couple others. That is the Sierra Club, importantly. I don't want to leave that group out. That's what this all comes from, is there was a lawsuit filed in 2002, and to settle that lawsuit, everybody that was part of it, the plaintiffs and the defendants and the judge had to agree to this, settled it with the consent decree itself. And there's a lot of material in the consent decree as far as larger engineering projects, different types of pipeline replacements, other things that are well outside of this. But this process was established as part of the settlement of that lawsuit.
Right. Okay. So okay, because I wasn't understanding. I thought it was all industry doing this lawsuit and not residents. That's what I was really trying to distinguish. And what I saw was something in 2008 and not 2002. So I guess I didn't do my search back in history far enough. So thank you for answering that question.
Okay, well, I'd like to thank Mr. Fitzsimmons for presenting at our SBU 101 program, and for all of you who have attended. We have it recorded, and we'll post on the CUFA news section at the website www.cufacincy.org, as well as on our YouTube channel. So just a note about the MSD Sewer Backup Program. If you have experienced the sewer backup from the MSD Public Sewer, you must report your backup to MSD within 48 hours of discovery. And like they've been saying, there's 2 ways to report your sewer backup. Call the number 513-352-4900. That's 352-4900, area code 513. Or you can submit your report online 24 hours a day, 7 days a week at sbu.msdgc.org/SBU. So with this, CUFA would like to encourage everyone to become a member and join our sewer justice team. We appreciate all of you who are willing to share your stories tonight. And we know that more people, we know that if more people share these stories, it's easier to identify improvements that can be made to the programs. CUFA has also wanted an extended time to report sewer backups and is advocating for notifications in every sewer bill about the sewer backup programs. We know that there are still people experiencing these issues but don't even know about the program existing. So help us spread the word, advocate for sewer bill notifications and other improvements to the program to make sure that everyone who qualifies for help actually gets help. You can contact CUFA at area code 513-853-3947. Again, area code 513-853-3947, or CUFA@cufacincy.org for additional questions or to get involved. And we know that this isn't the end, and we will be happy to follow up with you after tonight's meeting. So I'd just like to thank everyone, for their participation and all the information that has been given from Mr. Fitzsimmons and Mr. Frank. And I'm calling for the adjournment of the meeting tonight. So everyone have a good night. And
one quick thing, Florence. Matt Fitzsimmons put the number for the ombudsman's office in the chat.
Oh, okay.
513-362-2801.
362-2801.
Mm-hmm.
Area code 513. So that's the ombudsman number, which would be very helpful.
Great.
Okay.
Sorry to interrupt.
Thanks to everyone. Hope you have a good rest of the week.
Thank you, everyone.
And to all those mothers out there, or you have mothers, wish them a happy Mother's Day.
Right. Thank you.
Good night.
Thank you.
Thank you very much.
Good night. Thank you.
Bye.
Thank you.
Night.
Good night.